The New South Wales government planned to compulsorily acquire an area of land near Jervis Bay. It was essentially bushland, but the title had been divided into thousands of house lots in the early 20th century when it was anticipated that a town would be established in the area. The town never happened. Some of the land was beneficially owned by Sealark. This means they only had an equitable title to the land. They were not the registered proprietors. The case doesn't actually tell us a great deal more about the nature of their title. When the government resumes land in New South Wales, it's required to pay compensation. Sealark examined the mathematics of the compensation and realised that the total compensation for the land they held would be much greater if the New South Wales government had to separately assess each block of land, rather than assessing their entire holding all at once. To take advantage of this, they entered into agreements with a range of other entities, including Passanet. Under the agreement, Sealark transferred its interest in land to Passanet, and Passanet held those lands as a unit trustee, transferring units back to Sealark. The effect was that instead of one owner with many allotments, there were many owners, each requiring separate compensation. But then it all came unstuck. To make the mathematics work, they needed to avoid liability for stamp duty, which is basically just legalised robbery by the government. In order to avoid stamp duty, they didn't have written contracts for the transfer. The transfers just happened. Remember, they were equitable and not legal interests, so no registration was required. That left them in a situation where they could not prove that the transfer of the interest had actually occurred. The moment they produced documents to do so, stamp duty would be assessed. The court, however, said that without such proof, there could be no transfer of an equitable interest. The majority judges said, where an interest to be transferred is a creature of equity, equity requires a clear expression of intention to make an immediate disposition. Passanet could not show a clear expression of intention to transfer the land, and so the assessment proceeded as though all the land was still owned by Sealark. From this case, we learn that the transfer of an equitable interest requires a clear expression of intention to make an immediate disposition of that interest.